Choose Privacy Week. And so I intentionally had this topic now because we wanted to make sure you were thinking about privacy as we move into Choose Privacy Week. Anybody recognize that picture? Remember where you were when that happened? So just hours after the terrorist attacks on September 11, 2001, people rushed to libraries and to read about the Taliban, Islam, Afghanistan, and terrorism. Americans sought background materials to foster understanding and cope with the horrific event that had happened. So while the public turned to libraries for answers, the President and Congress turned to the intelligence community for techniques to secure our borders and reduce the possibility of more terrorism. The result? Congress passed unanimously, almost unanimously, sorry. My congressman in New York at the time was one of those that voted against it, but almost unanimously, the Uniting and Strengthening America by Providing Appropriate Tools Required to Intercept and Obstruct Terrorism Act. Did you know that the USA Patriot Act was an acronym? Yes, that's what it is. Right. It was a 342-page bill that became law 6 weeks after the events of September 11. Now, the act granted unprecedented powers to law enforcement to peer into Americans' most private activities through the gathering of intelligence and an investigation of anyone suspected of terrorism. Most troubling are the provisions of the law that grant sweeping authority for federal agents to search for business records, including those retained by libraries and bookstores, merely by claiming that the desired records may be related to an ongoing terrorism investigation or intelligence activities. Through a gag order, the Act also prohibits any person or institution served with a search warrant from disclosing what has taken place. Now, officially, librarians may not comment on FBI visits to examine library users' internet surfing and book borrowing habits. But that has not stopped them from speaking out about the chilling effects of the USA Patriot Act on their users and communities. Immediately following the terrorist attacks, the American Library Association joined forces with other civil liberties groups, mostly in Washington but throughout the country, to caution public officials against their eroding freedoms. In 2003, Washington insiders were warning librarians that policymakers were unreceptive to any criticism of this 342-page law, even though we'd already made it through the 2002 midterm elections. Nevertheless, a group of very determined ALA activists, led by a New Jersey librarian who's a Rutgers MLIS grad, began drafting a resolution to call on changes in the law. In January 2003, ALA crafted a strong resolution calling on librarians to educate their communities about the problems with the law and Congress to, quote, amend or change the sections of these laws and the guidelines that threaten or abridge the rights of inquiry and free expression. So after ALA passed its first resolution, and I will tell you, everybody said, don't do it. You know, Congress will never look favorably upon us again, and you really are cutting off all your political access. Suddenly, the media and Congress began examining the USA Patriot Act more closely. Hundreds of stories started to run in newspapers pointing out flaws, focusing on the impact of surveillance on civil liberties in general, and pointing to the impact on local libraries specifically. A tangible example that resonated loud and clear with the public and policymakers. So late that summer, This is a button. I would have worn my button, but I didn't have time to look for it. Late that summer, Attorney General John Ashcroft, in case you don't remember him, to bring him back to you, he launched a 16-city victory tour promoting expanded surveillance authority. And when he addressed the National Restaurant Association, of all people, he ridiculed librarians' concerns about the privacy of library users as, quote, baseless hysteria, and claimed that the ALA was, quote, duped by the ACLU. ALA fired back at him, quote, we are deeply concerned that the Attorney General should be so openly contemptuous of those who seek to defend our Constitution. That's a very unfortunate choice of words, and it does not accurately portray the concerns of librarians. Rather than ask the nation's librarians and Americans nationwide to just trust him, Ashcroft could allay concerns by releasing aggregate information about the number of libraries visited using the expanded powers created by the USA Patriot Act. Now, ALA went on to point out to Ashcroft that librarians have a history of combating FBI surveillance dating back to the McCarthy era, and reminded him that under the FBI's Library Awareness Program, agents snooped in libraries up until the 1980s. And I will tell you, that's how I got involved with intellectual freedom, because I was at New York University at the time, and those FBI agents came not just to Columbia, the well-known visit, but also to NYU, and I was the person who reported it to the press. So I got involved in these issues early on and started to realize what kind of effect these kinds of surveillance may have on the use of libraries. So the following day, Mr. Ashcroft telephoned ALA President Carla Hayden and told her that people have misunderstood his commitment to civil liberties, and promised to declassify the Justice Department's report on the use of Section 215, and that's the section, the business records section, the section we thought was the section we had the most problems with. We learned there's other problems too, but okay. So next, Ashcroft wrote in a memo to then FBI Director Robert Mueller III that, quote, the number of times Section 215 has been used to date is 0. He added that he had decided to declassify the previously secret information, quote, to counter the troubling amount of public distortion and misinformation in connection with Section 215. Hayden immediately expressed ALA's surprise to him, since that May, federal agents reported they had visited about 50 libraries. So they're having trouble getting their information straight over the Justice Department. But instead of backing off, Ashcroft stepped up his attacks when he stated, the fact is, with just 11,000 FBI agents and over 1 billion visitors to America's libraries each year, the Department of Justice has neither the staffing, the time, nor the inclination to monitor the reading habits of Americans. He continued, no offense to the American Library Association, but we just don't care. So, what we later learned, and we'll hear more about this evening, is that law enforcement was using another section of the law, Section 505, which permits the use of what they call national security letters, or NSLs. Hold on. To force the instantaneous production of information about targets of investigations without a court order at all, accompanied by what they call the same thing, a gag order, that requires any person or institution served with a search warrant to keep secret what transpired. So once the public found out about those visits, the libraries, many gave up their library cards in protest, concerned that their reading habits would become the subject of federal surveillance. And I will tell you, I gave a talk here in New Jersey at the time with the ACLU person, Ann Beeson, at a library up in northern New Jersey, and people came up to us afterwards and said that they had actually given up their library cards and stopped using the library because of this. So why should we protect privacy in libraries? What's in it for us? Well, first of all, privacy is essential to the exercise of free speech, free thought, and free association. When people fear they're being watched, they are reluctant to participate in democratic discourse and exercise their civil liberties. So just think, if somebody's watching you, are you going to be inclined to learn about some of these issues? Probably not. So that includes their right to read. Why would they want their reading habits revealed if the possible consequences include damage to one's reputation, ostracism from their community or workplace, criminal penalties, or even suspicion of terrorism? So in a library, the subject of users' interest should not be examined or scrutinized by others. A principle reflected in library confidentiality laws in 48 states, and the other 2 states have Attorney General's opinion. So every single state in the Union agrees that this is not some information that should be given out lightly. So when we fear that information about us will be misused, we lose our trust in public institutions. And we're certainly going through that right now, and our speakers tonight will talk more about that. So lack of privacy and confidentiality chills our choices, suppressing access to ideas. So keep in mind that motives and about our reading habits are not necessarily related. So how many of you like to read murder mysteries? Okay, so does that mean you're a murderer? So that whole idea of attaching a motive to what we read is really, really scary. So keep in mind, though, that in 2004, the FBI issued a subpoena to a library in rural Washington state demanding a list of people who had checked out a biography of Osama bin Laden. So clearly, they might not care that much about us, but they care enough to want to know who's reading some of these books, right? So librarians are staunch defenders of library users' privacy, even as new technologies and a growing use of social media and online tools have altered the privacy landscape. That's a quote this year for Choose Privacy Week from the head of our Intellectual Freedom Office, Barbara Jones. And she goes on to say that acquiring the tools and knowledge necessary to help library users address and cope with an era of nearly unchecked surveillance and data mining is essential preparation for librarians tackling this important task. Hence, why it's so important that you as students have the chance to think about these issues. Think about them before you get that visit from the FBI. So libraries clearly function under the rule of law and cooperate with law enforcement when presented with a lawful court order to obtain public specific information about specific patrons under their respective state laws. And most of us, I'd say just about all of us, are also committed to following the law. We don't want to be unlawful, but we're also, and we're just as concerned as anybody about keeping our nation safe. And I will tell you, I lived in New York City at the time. We were all really scared. I'm sure you were really scared. Living in New Jersey was not real comforting either, and many people from New Jersey were killed at the World Trade Center. But we've also been real leaders in the fight to advocate for changes in the Patriot Act and related laws to protect civil liberties in general and the privacy of library patrons in particular. So, tonight we're going to hear a story about some of America's most cherished freedoms and librarians' most fundamental core values: intellectual freedom, privacy, and the public's right to know. It has all the intrigue of a spy novel, all about secrecy, whistleblowing, and gag orders. Given the recent revelations about the National Security Agency's secret surveillance program, we're now a lot more knowledgeable and better positioned to push for those very reforms that we've cared about all along, and to articulate why library supporters and the general public should and must be involved in the debates. And I will tell you, last summer at ALA, after the NSA revelations, we had a speaker from the ACLU, and the title of our program was "We Told You So." tonight we're fortunate to have two people joining us who have a special relationship to the challenges facing libraries as they fight to protect patron privacy. Both have been instrumental in one way or another in changing the discourse and moving public opinion and policy toward more openness. They'll not only share their stories, but address the central question: where do you draw the line in a democratic society between safety and freedom? We will learn firsthand from a librarian on the front lines about the policy issues and why libraries should care about all those national security issues. And we'll hear from another who just said no to an FBI fishing expedition that demanded records about the hundreds of thousands innocent readers using his busy libraries. And then each of you can decide for yourself whether librarians are really hysterical about protecting the intellectual freedom rights of our users. So, I'm going to introduce each speaker before they speak, so when they come up to speak, you can have a better sense of them. So we're going to start off with our first speaker, and that is George Christian. So, George Christian is the executive director of the Library Connection in Connecticut. Now, the Library Connection is a consortium of 1 academic and 30 public libraries funded by its member libraries to run a common integrated library system for its members. Pretty benign, don't you think? A backroom operation, as some would say. The system lists nearly 4 million books and other materials in its catalog and serves 350,000 patrons who borrow over 8 million items annually. George is also a trustee of a fund dedicated to the support of the Fairchild-Nichols branch of the Trumbull Library, and he was formerly on the Trumbull Library Board and Branch Advisory Board. But most of us don't know George as George Christian. What we know him better as is the plaintiff, John Doe. In the case John Doe versus Gonzalez. After the FBI used a national security letter in 2005 to demand patron records from his library consortium, the Library Connection. Now, the ACLU represented John Doe's case against the U.S. government challenging the constitutionality of Section 505 of the USA Patriot Act, the section that allows the FBI to issue such an administrative subpoena without any judicial oversight. No checks and balances, no courts involved. John Doe and his lawyers were bound by a gag order preventing, and his colleagues, I might add, who are all in this picture, preventing them from discussing or even acknowledging the government's request. Now, at the time, Congress was in the midst of a critical debate over reauthorization of the Patriot Act. One of the key issues was whether the government had used the Patriot Act to demand information from libraries, revelations of which would have violated the gag order of the USA Patriot Act. The Connecticut 4, which is the John Doe's that you see on the screen, this case was the first and one of only a few ever brought to court. And what they did was they took this case and got the government to lift the gag order. So because of their case and the government lifting that gag order, and they're winning the case, I should say, the 4 librarians involved are now permitted to speak publicly about the government's attempt to search the consortium's patron internet records. Unfortunately, though, not in time for when Congress was debating the law's continuation and keeping certain sections from sunsetting them, or to receive the award of valor that he got after that, after his brave actions. So John Doe and his identified employer were named the recipients of the 2005 Robert Towns Intellectual Freedom Award, a prestigious award given by the faculty of the Graduate School of Library and Information Science at the University of Illinois. But because of the gag order at the time, they could not even appear at the event to get the award. But later, George was named Librarian of the Year in Connecticut, and in 2007, he received the Roger Baldwin Medal of Liberty from the American Civil Liberties Union, the Paul Howard Award for Courage of the American Library Association, and the CSRS ProQuest Intellectual Freedom Award of the ALA Intellectual Freedom Roundtable. Boy, that's a whole mouthful, isn't it, George? His testimony before Congress about his experiences required reading in several of my classes, so if any of you have taken or wish to take my classes, you'll get to read all about George. So when giving the award to George, in his absence though, then Dean of the University of Illinois School, Lee Easterbrook, said, "It takes courage to defend the principles of intellectual freedom in libraries, to insist that every person has the right to read, think, and acquire without fear. This year, we honor an unnamed individual for his or her courage in defending intellectual freedom when it was not even possible to talk to friends, family, or other professionals. This person not only stood alone at the moment of upholding principle, but has to remain isolated because of the gag order under the USA Patriot Act. I'm delighted that George, Christian, and not John Doe, is here tonight, and I'll let him tell his remarkable story. Any of you who've taken any of my courses have had a chance to get familiar with his work, and indeed tonight all of you will have a chance to hear about him. Let me close and introduce him by saying that George Christian is one of my great heroes, and it's wonderful to have you here, George.
All right, it's hard to speak. I'm all choked up after that introduction. I thought you were talking about someone else. I think what I want to do tonight is relate the experience as it happened to me, but also try and illustrate that I was extremely fortunate. Talking with you about if you encounter a situation like this in your own professional life, how are you going to deal with it? And the short answer is you can only deal with it if you're prepared. I was unbelievably lucky that unprepared was able to deal with it and deal with it successfully. It started out in June of 2005. The FBI actually called Library Connection. They talked to my head of telecommunications at that time and said, we're going to serve you with a national security letter. Who does it get addressed to? And he said, oh, that goes to the executive director. And that was our first bit of luck. When the Patriot Act was first promulgated, when the American Library Association began to try to raise consciousness about it, there was a seminar in Connecticut on national security, on the USA Patriot Act, and on dealing with the FBI, and I went to it, and the one thing I walked away from that seminar with was, you really have to make sure that everybody in the organization knows there's only one legitimate recipient of any kind of court order or any request for action. And in our case, that would be the executive director. In a library, it would be the library director. This prevents lower level staff from having to make decisions or from being taken advantage of. The FBI loves to show up on a Sunday when there's a part-time employee there, and bing. So I my first degree of luck was that I knew in advance I was getting a national security letter. At the time, I really didn't know what that meant. I called our attorney. The University of Connecticut School of Law runs the Connecticut Urban Legal Initiative, which provides nonprofit corporations like us with free legal assistance. And I said, the FBI just called, we're getting a national security letter. What's that? And she said, I've never heard of it either, but I'll get back to you. She had a grad student available and called me back in the afternoon and said, well, my grad student did a little research and discovered that a national security letter is a subpoena-like instrument that the FBI can issue, but there's no court review. There's no judicial review. There's no finding of probable cause. And in fact, an internet service provider in New York has sued the federal government over national security letters. And at the district level, they won the case hands down. The district judge declared that a national security letter violated the First, the Fourth, and the Fifth Amendments. So, armed with that piece of information, I said, okay, that's great. I know what I'm going to do. And for the next 2 weeks, I showed up to work like I am now, with a jacket and a tie. I wanted to be presentable when the FBI arrived. Normally, we're a bit more casual than that. And I was just about to give up, but 2 weeks later, in walked the FBI with what really I took to be a good cop, bad cop kind of routine. There was a nice young man dressed exactly as I am, blue blazer, tie, all smiles, a little short in stature from my perspective. And then he was accompanied by a much bulkier person wearing a spandex t-shirt. So I knew exactly how robust this guy was, just sort of in the background. And they have really great badges if you ever get to meet an FBI. It's huge. They open this wallet-like thing, and it's gold. I mean, very impressive. And all the psychology starts, geez, it's the FBI, let's help them out. And he presented me with the national security letter that you see there. I was very relieved because even in his hands, I could quickly read that this was July. They were concerned about an incident that happened in February. B, the letter was dated in May. It was still addressed to the person that they had called on the phone. It's not addressed to me at all. And now it's July. So immediately I realized this is not a case of hot pursuit. If I refuse to cooperate, I'm not putting any of my fellow citizens in jeopardy. And that was a great relief. So the FBI agent was not worried about that part of the letter. He wanted me to read the paragraph near the bottom that essentially said there's a perpetual gag order, and that not only couldn't I tell anybody that I had received a national security letter, I could not tell anybody that the FBI had even been by to visit me. And I said, well, this is very nice, but I understand that there is a court in New York that's questioned the constitutionality of national security letters. I'd really like to talk to my lawyer. And he said, sure. Whipped out a business card, wrote down the name of his attorney on the back, and said, have your attorney call my attorney. Don't worry about it all. And good cop, bad cop left. So I got back on the phone with my attorney. He said, hey, the FBI was here with a national security letter. I told them to get lost. Now what do I do? And she said, unfortunately, if you really wish to contest cooperating with the FBI and you wish to contest the gag order, the only thing you can do is sue the Attorney General of the United States. That put a different color on things. I could see where this was going. It was not impossible to see that if I was challenging the constitutionality of an act by the FBI, it might get up through the federal courts all the way to the Supreme Court. And I did not feel that I could commit my organization to do that simply because I wanted to. I was in a bit of a bind because the national security letter clearly stated I couldn't talk to anyone. And I decided to temporize. In addition to having a board of directors, 3 people on that board of directors, 3 officers, comprised the executive committee. So for the first time in our history, I convened a meeting of the executive committee and said, it's really important, you gotta come. I showed them the national security letter. I said, this is the story. We gotta sue the Attorney General. I want to do that, but I can't, you have to make that decision. I cannot commit this organization. We're a very well-run organization, even though all of our funding comes exclusively from our member libraries. We pinch our pennies. At the time, we had $1 million in capital reserve funds. I could just see that going up in attorney fees, and that's why I couldn't, in conscience, make the decision on my own. But they were librarians, and they said, hey, wait a minute, the law says we have to protect patron privacy. That's what we're all about. That's what the ALA says. That's what we believe. Of course we're going to sue. So that was great. I was so relieved. I called our attorney back. She said, gee, that's great, but my mandate doesn't run to suing the Attorney General. I'll look around and see what help I can get you. Well, fortunately, the ACLU was looking for a case like this. Librarians are a good profession in the public eye, and they just wanted to have, most of their plaintiffs are frequently not people that the public can empathize with. That's what makes them such a vital part of our democracy. But librarians could get public backing. So Ann Beeson and her colleague showed up a couple of days later and talked to us, and we agreed that we would sue. But then we found out that the gag order was really, really serious. They said, we are not going to conduct business on the phone. If you want to see us, or if we want to see you, you have to come down to New York, meet us at our national offices in New York. Very little information on emails, and really you can't talk about this to anyone, nor can your staff. But they did arrange for us to sue the Attorney General. The case was held in district court in Bridgeport in September, and my first shock was I couldn't go. I said, wait a minute, I'm the plaintiff. What do you mean I can't go to the court? And from the national security point of view, if I were in the audience in the court, then I would be identifying myself as John Doe. I said, talk to the judge. That just doesn't sound right. The judge bought the argument of national security, arranged for my 3 colleagues and I to be in a district federal court in Hartford under an armed escort, where we watched this on closed circuit TV. And it was fascinating. We really got to see the whole trial. And the interesting thing was that at the end, the judge said to the government, I really don't see that you made a case here. I will consider this carefully. I will write out my ruling, but I'm inclined to say that you don't have a case, and I will rule in favor of the plaintiff. Is there anything that I should know that would make me change my mind here? And the government said, yes, there is, Your Honor, but unfortunately it's classified. And she said, well, it just so happens that before I was appointed to the bench last year, I had the highest national security clearance, so fork it over, I'll look at it. And having read that, she ruled that the government had no case and was lifting our gag order. But she stayed her ruling to allow the government to appeal. And the government did appeal, so we would have to go to the court in New York, the appellate court in New York. Now, immediately there was a lot of publicity, but we felt that's all right. It's something that the public needs to know about. And we're John Doe, we're sort of fine. And I even joked with our attorney, just my luck, my 15 minutes of fame, and I'm John Doe. So, fine. And we proceeded from there. All of us submitted affidavits as part of the court case, and other people filed, including the ALA, filed amicus briefs with the court. And the judge insisted that all this material be on the court website associated with the case. The FBI had been dragging its heels, or the Justice Department had been dragging its heels over publishing this stuff, and the judge said, no, tomorrow morning it's going up. You and the ACLU work through the night and redact all this stuff. So they took black markers and redacted everything that they thought would jeopardize the government case or reveal who we were. But working in great haste overnight with a lot of documents, they didn't redact everything. And within a couple of days, the New York Times published Library Connection as the plaintiff, published my name, and published the name of our president at that time, Peter Chase, because somewhere in the documents, they had failed to redact the fact that he was the chair of the Intellectual Freedom Committee for the Connecticut Library Association. Now, how many people fit that bill, right? You call the Connecticut Library Association and say, who's the chair of the Intellectual Freedom Committee? And they say, oh, it's Peter Chase. So, boom, there he is. So, lots and lots of newspaper publicity. This made it very, very difficult for all of us. In theory, we couldn't discuss this with our families. Some of us did, some of us didn't. But even if you did discuss it with your family, you were putting them at risk. Because not only was it in the New York Times, it was in Hartford, it was, Trumbull has a paper once a week. You know, I was there, page 1, center, big. George, how many George Christians are there in Trumbull, Connecticut? What am I going to tell my wife? No, that's not me. Plus, I had a son who was in high school. Trumbull, he was in a constitutional law class. Trumbull participates every year in a national contest called We the People, which basically defend parts of the Constitution. And Trumbull had an unblemished history of 17 years of being the state champions in this. So, you know, I really had a choice here. Do I teach my son that you prevaricate, or do I teach my son that you stand up for what you believe in? But I was again putting him at risk. The same deal. My wife and my son were very good about it, but I didn't like that. Whenever the phone rang at home or the phone rang at work, my staff were also, I mean, of course they knew the FBI was there. When I said, you know, even though it's normally our policy to answer the phone before the third ring, because we're a service organization, you must let it roll over into voicemail. And if it's a newspaper reporter, you don't call them back. If it's one of our libraries, you get back right on the phone and apologize for not picking up on time. And our home phone went off the hook all the time. And what really surprised me is the New York Times reporter who broke the news that I was John Doe left her business card in my mailbox in Trumbull. It was really, really scary. I called the ACLU. I said, so what do I do? She said, well, don't go outside for the newspaper in your pajamas. Because the press might be there. But the press were good, fortunately. And I couldn't, my instructions from the ACLU were, you cannot even say no comment, because that implies that you have something that you would comment on. And on those rare occasions that there was a slip up and I actually ended up on the phone with the reporter, all I said was, I'm not talking about that today. Whether I knew anything to talk about or not, I'm just not talking about it. And they all said, yeah, they understood, but boy, if you ever get lifted from that gag order, call me first. So that's really where we were. We did have a lot of support from ACLU, and by the way, they were free. We were not putting our $1 million kitty at risk. And they had a little bit of fun with it. They did posters like this, with this cyborg patriot raiding the library, having tied up the librarian. But, you know, it's really hard. The whole world knows who you are. Here's a piece in the New York Times talking about the fact that we couldn't go and pick up our award in ALA Midwinter at San Antonio from the University of Illinois. It says George Christian wasn't there, Peter Chase wasn't there. Why weren't they here when this award was being given out? They didn't actually say that we were the recipients, but it was interesting. So then, to show you where this redaction goes, this is the unredacted and the redacted version of the same thing. In my affidavit to the court, I mentioned that 48 of the 50 states have a statutory requirement that librarians take active measures to protect privacy of the patients, of their patrons. And somehow the government felt that this statement, that this is the law in 48 out of the 50 states, was a threat to national security and was redacted. At the same time, the Attorney General is going around telling Congress that there's no legal basis for privacy. Redaction's a powerful tool. You can just blot out the opposition. They never said that. Fortunately, the gag order was eventually lifted, but only after Congress had revised the USA Patriot Act. And then we could speak out, and then we got to speak all over the United States. The four of us have been in probably 30 of the 50 states speaking out about this. But it was a very harrowing experience. And good things came out of it. We got nice publicity, we got editorials, and we even got my favorite thing, an editorial cartoon. Yeah. I had a signed copy of this that we gave to Ann Beeson as our thank you to her. We got it framed.
Yeah.
And she told me recently she still has it in her office. It's one of her most favorite mementos. But I want to tell you, that, so this is my story. It was harrowing at the time. I later was on a debate with the prosecuting attorney from the federal side at the Old Hartford State House, in which we both talked about the case now that we were free. When we weren't free to speak, he was going around and saying a lot of things. Normally, he debates Peter Chase as chair of the Intellectual Freedom Committee, but Peter couldn't do anything. Peter had to turn down invitations to speak, where this guy's going around talking all the time. But at this thing at Harvard, he actually said that, yes, he and his staff spent an entire afternoon figuring out all the things they could charge us with, all the federal statutes that we would be violating if we violated the gag order. They really wanted to nail us. And we were very, very lucky that we escaped that kind of thing. He also revealed what the whole case was about. What they really wanted, I'll send you guys the national security. What they really wanted to know was, on a certain date in February, who was using one of the IP addresses that we owned. And they gave really a 15-minute time interval. They were that specific. They really wanted to know. And of course, we knew that that IP address was assigned to a library, and that really it went to probably the switch or the router at the library, and all of these switches or routers use net address translation, which means that the PCs behind that switch or router are assigned an IP address randomly every time they boot up. So we could identify the library, but we certainly couldn't identify even which PC was being used, nor did we have any evidence that whoever was using that PC was actually a registered patron at the library. So we felt that if we caved in on this thing, we would eventually be asked for a list of the patrons at that library, and we would be exposing a large class of people to the scrutiny of the FBI, when the FBI could not demonstrate that one of that population was actually a person of interest. So that's why we just dug our heels in. And to this day, we haven't revealed which library that was. That's our little secret.
Wow.
But what this prosecuting attorney revealed to me, or revealed to the public at this debate I had with him, somebody asked, so what were you looking for? He said, well, we got an email from that email address informing us that a certain party was involved in terrorist activity. So we wanted to talk to the person that had sent us that email. And I said, you mean, you're saying that it's the FBI policy, if you get an anonymous tip, you're going to turn heaven and earth upside down to find out who gave you the anonymous tips. How many anonymous tips do you think you're going to get in the future? You know, this just really doesn't make any sense at all. But that's the problem with secrecy. When you will never be accountable for your actions, you tend to act with impunity and do unaccountable things. And from a civil libertarian point of view, that's my whole problem with acts like the National Security Letter or the USA Patriot Act. People go to libraries for a lot of reasons. You know, if a housewife or a woman, it's not that you can go there, a woman is in the library reading up on breast cancer or other kinds of cancer, does she really want the world to know that this is a concern of her? Or if a woman's there reading up on divorce law, when her husband comes in as part of the FBI or even the local police and wants to look at the records, is he investigating a criminal case or he just wants to see what his wife is up to? When a student wants to know more about the Taliban or wants to know the difference between Shia and Sunni Islam, is that anyone's concern but theirs? When a businessman wants to find out what the opportunities are in the Middle East, is that anyone's concern but his? You really can't allow, you know, take my word for it, that this is a criminal investigation. And we won and we lost. There had been enough publicity that when the USA Patriot Act was revised, there were a couple of changes that were in the public's favor. One, the current letter clearly states that yes, you're perpetually gagged, but that does not mean you can't talk to a lawyer. It was really uncertain whether I even had the legal ability to talk to a lawyer. It also says that yes, you can appeal your gag order, but you can only appeal it after 1 year. And when you appeal it, the Justice Department declares that this is still a national security issue, the government must rule in favor of the Justice Department without any supportive evidence whatsoever, just a pure declaration. So it's a sham that you can appeal your gag order. And certainly no judge would ever be able to do what our judge did and said, I've got a national security clearance, I want to see the evidence. You can't do that anymore. And also the revised national security letter excludes libraries from being targets of national security letters, except for those libraries that provide internet service.
99.9%.
Right. I'm sure somewhere in Appalachia there's a library that doesn't have internet service, but that's not one. So, I want to stress that we were extremely lucky. We were totally unprepared. The only preparation we took was making sure that when the police or law enforcement came knocking, they spoke to me and me only. But we had no other preparation. We were lucky that when I asked my executive committee to make a decision, that was the top of the pyramid. There was no one that they were accountable to. We were lucky that our funding does not come from the government, doesn't come from the federal government, doesn't come from the state government. There is no county government in Connecticut. All our funding comes directly from our libraries. We assess them each year. We were really lucky that we weren't prosecuted for violating the gag order. Those of us who discussed it with our families, I discussed it with my executive committee. It was, you know, we were very fortunate that way. And we were lucky that we could actually win an appeal here. The government couldn't say, no, it's still a national security letter. It's a national security issue. We won. I'm sure most library professionals would want to do the same thing I did. But if you're going to stand a chance of being successful, you got to think about getting your ducks in a row before that happens. Think if you're a public library, who is going to represent you
when you sue the Attorney General of the United States. It's going to be your town attorney. And when you get that NSL, you don't want to go to the town attorney and have him say, hey, it's the FBI, let's help them out. Not the right answer. You don't want to get in a really messy PR contest with everybody else in town who may think that helping the FBI is a good idea, especially if they're also on the library board. We were really, really lucky. The FBI would not identify why they wanted this information, so the public did not perceive the fact that they were being threatened. They thought that libraries were being threatened and that library records were being threatened. So of course the public was on our side. The press was on our side. We were really, really lucky here. If it's a case in which the FBI is willing to intimate that there is a terrorist threat here, then all of a sudden, you're screening terrorists. So what do you do? Well, the first thing is you need to educate your board and have your board educate your town. And don't pepper the board with all this good stuff from the ACLU or even the ALA. You can use some of the ALA material, but go to, it used to be easier. You could go to the American Bar Association. Their website used to be chock full of nasty things about the USA Patriot Act and about national security letters and all of that. I've just checked today, and they've tempered that down a lot. They're equivocating. But there are a lot of American Bar Association publications, which your library and public interest should have on hand, that talk about threats to privacy, threats to the Constitution that are inherent in these issues. So educate your board. Have your board know that I think 12 states and 30 municipalities, at least back in 2005, had condemned, passed resolutions condemning the USA Patriot Act and all of the provisions that allowed for gag orders, that allowed for secrecy without judicial review. Get your board to come to its own conclusions through their reading that maybe the library ought to have a policy on this, and publish your policy. Once the board is on your side, get your town on your side. Say to the town fathers, this is what the board feels, this is why, here's all the stuff. Can we have a town conclusion that will back the library? That if we feel that the constitutional protections of our citizens, our library patrons are being threatened, will the town attorney support us? If you make those decisions when it's abstract, and it's a lot easier than making them in the heat of the moment when you don't know which way the press is going to go. So being prepared is really what you have to do. If you're in an academic institution, I'm not that familiar with academic politics, but certainly it's going to be the attorney for the university or the attorney for the college that will be calling the shots. And you have to figure out a way to get the university and its attorney on your side when the issue is abstract, before it's in the heat of the moment. And otherwise, not only are you jeopardizing your chances of winning, you're also jeopardizing your career going forward by getting entangled in something like this. It's a terrible choice to have to make. And it's much better if you can make that choice knowing that you've got your ducks in a row and that people at least have said that they will back you. The heat of the moment is absolutely the wrong time. You can't count on being as lucky as we were. And the FBI probably has dropped the policy of giving you 2 weeks' notice that they're coming by to deliver a national security letter. They'll do it on a Sunday afternoon. Your staff has to know to come to you. And you really need a published policy so the public knows what your policy is. The public knows that you're on their side. You're trying to protect their privacy, their interests. And there are lots of other good things you can do. Don't keep records you don't need, et cetera, et cetera. But I'll stop there. And I understand we're going to have opportunities for questions after this, so thank you all.
So our second speaker is Patrice McDermott, Executive Director of the coalition OpenTheGovernment.org. Patrice became the coalition's director after more than 4 years as the Deputy Director of the Office of Government Relations of the American Library Association, on our Washington office. At ALA, she had lead responsibility for government information and privacy policy and e-government policy issues. Patrice joined the ALA Washington office after serving for 8 years as the Senior Information Policy Analyst for OMB Watch, now the Center for Effective Government. Before that, she was the Assistant Director of the Office for Intellectual Freedom of the American Library Association. And I think she's probably the only person that's ever served both the Washington office on the legislative side and in the Intellectual Freedom Office in Chicago. So it's an amazing feat to have survived those.
Have survived both, right?
She also taught information politics at Clark Atlanta University and worked at the National Archives and Records Administration. Patrice has a doctorate from the University of Arizona in political science. I'm trying to put all this together because it's like she's zigzagging across the world. She's in Georgia, she's in Washington, she's in Arizona. She's a master's in library and information management from Emory and an MA that Emory used to have a program.
Yes,
It's one of many programs that closed, another issue, but
Yes.
Hopefully we won't have that issue before us anytime soon again, but right. And an MA from Brown University and a BA from Florida State. So indeed, she's been here, there, and everywhere in the university land. She's the author of a book called Who Needs to Know? The State of Public Access to Federal Government Information. I just checked it out of the library. I want you to know we had 2 copies.
Oh,
So, yes, right.
you can start a rush to go get the other one.
Right. The other one's in Camden. So.
Ah.
Okay. In 2001, Patrice was inducted into the National Freedom of Information Act Hall of Fame. And then in 2011, she received the James Madison Award from the American Library Association on Freedom of Information Day in recognition of her work to champion, protect, and promote public access to government information and the public's right to know. Okay, there she is receiving it. It's a wonderful plaque. It's glass. Really, I hope you have a very special place.
Thank you.
At the award ceremony, ALA President Roberta Stevens, who's with her, said of Patrice, she joined the ALA Office of Government Relations just days after 9/11 and was a tremendous leader within our community and for all of us here today in the struggle to bring balance to the USA Patriot Act and the many related and very challenging issues on surveillance and privacy. Patrice is going to give us an up-close and personal perspective on the policy framework environment, including secrecy law and why this is important to us. Please join me in extending a warm welcome to someone at the forefront of the fight against government secrecy who has shined a light on surveillance transparency, Patrice McDermott.
So let's take this. How do I close that? Let's see. How do I get out of this completely?
Just press the escape.
You're right there, and show.
And show.
Or escape. Yeah.
I can't escape in it. I know.
We're all Mac users, that's the
Yeah.
problem.
Okay, I'm going to close it up. Well, actually, I want to be able to put mine up at some point. So if you could, thank you. There we go. Yeah, no, that one's fine, but I'll put it up. Okay. So thank you all for coming out tonight, and thank you for those who are watching remotely. Welcome, and we will hope you will have some questions for us in half hour or so. So George talked about teaching your boards and your colleagues and your city attorneys and your university attorneys, and we actually have a very teachable moment currently because of the leaks, the disclosures, whatever you want to call them, of information that, to be honest, Edward Snowden stole from the National Security Agency. You know, let's not gloss over what he did. What he did is a criminal act. He took information that's government information. However, what he did in the process was to expose the lies that we were being told by the government, the lies that Congress was being told, and has opened new doors for change to possibly occur. There's good rhetoric going on. So my organization, you'll have to excuse me, I've got allergies on top of other problems. Every year since about 2004, we've put out what we call a secrecy report. And we take government information and make it, package it, and explain it. And we've been reporting for since, I think like 2009, on the number of national security letters that the government was issuing. And they actually have to report on this. They send reports to the Senate, and those reports are made public. And so, you know, we've been reporting on the number of NSL requests. There were 15,299 in 2012, and these NSL requests were made after some changes in the law to the Foreign Intelligence Surveillance Court. To back up a little bit, the Foreign Intelligence Surveillance Court was set up as a result of the 1971 break-ins that were made by some activists in the Media, Pennsylvania FBI office. And they went in one night when there was a big prize boxing fight going on, and they had planned this very carefully. They went in, they broke into the office, and they took all the files. And what this led to was the revelation that our government, the FBI in particular, had been spying on Martin Luther King, had been spying on anti-war protesters, had been spying on all sorts of people. Eventually, this led to the Church Committee that some of you may have heard of, that was this congressional committee that looked at all of these transgressions, these violations of our Constitution. And one of the things that came out of that was the Foreign Intelligence Surveillance Act that the USA Patriot Act amended, but they also created a Foreign Intelligence Surveillance Court that was supposed to oversee the activities of the intelligence community. So we had been thinking, well, the FISC was keeping an eye on all this, and the FISC was approving these NSLs, and they were approving these requests that the FBI made to go get records. So that we learned that the number of FISA applications that were presented and approved for authority to conduct electronic surveillance and physical search, so going in and getting any tangible thing, which is what the Section 215 of the Patriot Act says, that there were about 1,800 of them in 2012. What we didn't notice in our readings of these notices from the Justice Department was that they were also reporting on Section 215 requests. And we didn't really know, they were applications to the FISC for access to certain business records, including tangible things for foreign intelligence purposes, which is what the law says. The numbers were really low. There were 43 in 2006, there were 6 in 2007, up to 21 in 2009. They jumped to 96 in 2010, and we're up to 212 last year. Of those 212, the FISC denied none, but modified about 200. So they looked at all of them. But the dramatic increase in the numbers from 43 to 212 only tells a sliver of the story. Before Snowden leaked the Foreign Intelligence, the FISC order court to Verizon, we assumed in openthegovernment.org and a lot of other people, along with nearly everyone else, that provision, that section 215, was being used in discrete, limited requests to obtain individual collections of information, of records, about known counterintelligence or terrorist suspects. They were already told they couldn't go to libraries anymore. For records showing that a certain, this is what the law says, showing that a certain person made certain purchases from a certain vendor or used a particular telephone to make specific calls. In an example of what we see as misdirection, the government has suggested that these orders were comparatively rare, up to 212, and focused on specific business records. The acting head of the Justice Department's National Security Division testified in 2011 that, quote, some orders have been used to support important and highly sensitive intelligence collection operations on which this committee and others have been separately briefed, Intelligence Committee. On average, we seek and obtain Section 215 orders less than 40 times a year. Nothing to worry about, nothing to look at over here, you know. Look over there, nothing going on here. So we were distracted by the small numbers, and until the Snowden revelations, we were prevented from knowing that behind those 212 requests were the massive numbers involved in the bulk collection of metadata on calls wholly within the United States, including local telephone calls. In addition, last summer we added a new term, hops, to our vocabulary. In his testimony before the House Judiciary Committee last year, NSA Deputy Director John Inglis stated that the FISA court has approved us to go out 2 or 3 hops. Now, a hop, one hop is they get information, so they get a 215 order on your phone, and they get to see everybody that you called, or that called you. 2 hops, they get to see everybody that they called, or they called them. 3 hops goes out to everybody in that expanded circle who called them and who they called. So at one point, we learned that the NSA was going out up to 4 or 5 hops, which takes in potentially millions of phone users. So what the Post explained that when analysts think they have cause to suspect an individual, they will look at everyone that person contacted, called the first hop. Then in a series of exponential ripples, they look at everyone, all those secondary people communicated with, and they look at everyone the tertiary people contacted. As members of the committee, the Intelligence Committee, were quick to point out, that's not what the law says. The law says you can go for a specific record on a specific person for, on a specific phone. But NSA claimed, well, the FISA court, the FISC, authorized this. But in an 85-page ruling that was declassified and released last summer, Judge John D. Bates, who was then serving as a chief judge on the Foreign Intelligence Surveillance Court, wrote that the court found its approval of the government interpretation of Section 215 was that it justified bulk collection of all Americans' phone records was, quote, premised on a flawed depiction of how the program operated, and, quote, buttressed by repeated inaccurate statements in the government's submissions to the court. So not only was were the NSA and the Department of Justice misleading the American public, they were lying to and misleading the courts. Did the courts call them out publicly? No. The FBI and the NSA will also claim that because they gave briefings to the intelligence committees, that these new expanded authorities, which are worse even than what was done to George, were authorized by Congress. Congress will dispute that and has disputed it. So they haven't been, they're not what the law says. They're clearly not what the law says. They were not officially authorized, but they were authorized. They were cleared by the courts. But we wouldn't know any of this, not a shred of this, if it weren't for Edward Snowden. As an example, we had been asking for the courts to declassify their FISC opinions. And that has to be done by the Justice Department. And we had been told last summer, actually last May, by the Justice Department, we looked at this and we really tried to do this, but you know, the operational details are just too intertwined with the opinions, and sorry, but we can't do it. And we were all ready to, we weren't happy, but everybody was ready to accept, okay, there's not a lot we can do, we can't prove them wrong. And then Snowden released one of the letters, one of the opinions, and then the judges started releasing, a few judges started releasing, declassifying and releasing the FISA court opinions that they had written, proving that what the Justice Department had said was a lie. But again, it was a misdirection of the public, and it was a misdirection of Congress. The other section of the, that it's not a section of the Patriot Act, it's a section of the FISA Amendments Act of 2009, yes, 2008, Foreign Intelligence Surveillance Amendments Act, confusingly called by folks in Washington the FAA. So it's very easy to think, oh, well, what does this have to do with it? But that's my problem. Section 702 of that act permits the real-time bulk collection of Americans' overseas communications, telephone calls and email, including associated metadata, as long as the government is targeting foreigners abroad. The section says surveillance may be authorized by the Attorney General and the Director of National Intelligence without prior approval by the FISC, as long as they follow the minimization requirements. Once they get the information in, they minimize what they keep and what they do with it. In August of last year, though, we learned that the NSA has not always operated within the strictures that were set for them. In the ruling I mentioned just a minute ago, Judge Bates said the agency had violated the Constitution, and he noted serial misrepresentations to the court. The court is troubled that the government's revelations regarding NSA's acquisition of internet transactions marked the third instance in less than 3 years in which the government has disclosed a substantial misrepresentation regarding the scope of a major collection program. He said that the NSA is likely to continue what it was doing, that they have acquired or has acquired or is acquiring and will continue to acquire tens of thousands of wholly domestic communications. And indeed, according to the report of a conference call about declassification and release of that ruling, intelligence community officials said that the FISA court paused the program, which they did, because They were not meeting the minimization standards. They were not getting rid of wholly domestic stuff like they were required to do. But the court, NSA said, found that it was technologically impossible to prevent this from happening. And that the court found the NSA's procedures for purging wholly domestic communications needed to be beefed up, and that's what was done, but it wasn't. Senator Ron Wyden has noted that the ruling exposes the failure of Congress to address what the ruling notes, that the warrantless acquisition of wholly domestic communications, including emails, continues and violates the spirit of the law. So the Foreign Intelligence Surveillance Court, as I said, was established under the Foreign Intelligence Surveillance Act, 1978. And it was intended to act as a brake on the government, to make sure that they didn't violate civil liberties, didn't violate the Constitution in keeping us safe in that time from lefties and civil rights activists, and now from anonymous tips. However, it's not a court in the same sense that most of us think of a court. It's not what my colleagues in Washington call a Title III court. It's not set up under the Constitution. And only the executive branch can submit requests. No one outside the government can appear before the court or the judge, and its rulings and its opinions, except for these few that have been released, are all secret. The FISC was set up to approve warrant applications for surveillance activities. But as some of my colleagues have pointed out, it seems to have operated for years, prior to 9/11 even, in a manner, it seemed to have operated in the manner that Congress intended. But after 9/11, and recent revelations, again from Edward Snowden, raised significant questions about the court. Instead of approving one-by-one warrant applications, like a police officer or a marshal would go and get from a judge, they're now reviewing and approving bulk collections and what they call programmatic surveillance. And they're obviously, like I said, no longer simply reviewing warrant applications, but they've been extended, and then now their authority has been extended, and they now have the authority to permit electronic surveillance of entire categories of non-U.S. persons without the need for a court order for each individual target. The FISC started out and has continued as a secret court. And as Eric Lichtblau, a New York Times reporter, has noted, has quietly become almost a parallel Supreme Court, serving as the ultimate arbiter on surveillance issues and delivering opinions that will most likely shape intelligence practices for years to come, according to current and former officials familiar with the court's classified decisions. So where are we now? So we've talked about the 2001 version of the Patriot Act and of Section 215 and of the early criticisms. The 2006 amendment to Section 215 said only the FBI director or deputy director or assistant director of national security could authorize an application for library circulation records. Current legislative proposals, and this is probably very, very hard to read. Let me close this one. This will be made available, I presume, to folks. This is lifted from, and I gave a little bit of credit down to Farland, but The Guardian did a very useful comparison of what the current laws allow, and several of them don't make many changes to the current status. The one that people in the Washington area are supporting is the Senate and House Judiciary Committee USA Freedom Act. The USA Freedom Act, let me get that bigger so I can read it.
In the bottom right, there's a slider.
Yeah, there,
Ah,
or there's also.
yes, thank you, sir. There we go. So the USA Freedom Act would, this goes into probably more detail than you want to know, but one of the questions that people have is, so the president has committed to, in his speech in January, to not having the NSA collect this information, bulk collection of information anymore. The question, but they don't want to give away the ability to search this information. So they want somebody to collect it and somebody to retain it. Well, currently the telephone companies collect this information and they retain it, mostly for billing purposes. They don't really want to collect it. They've been making it available to the government. They're wanting to be able to reveal, actually they want to reveal when they've had the request from the government to share this information. They want to be able to give at least aggregate numbers in each period, how many requests. Google, Yahoo, all of these folks want to do that because NSA has gone out to everybody getting this information. So the USA Freedom Act the government wouldn't be collecting it, the telecoms would. It would be held for 18 months. Oops, I'm doing the wrong one. It would require judicial approval before they could acquire user data from a telecom or email provider, instead of just being able to go out with these warrantless letters. They would have to have a court order. One of the things that people have been talking about, and both the president or several bills out there, would create a privacy advocate on the FISA court. And this would be somebody who, when there's something coming before the FISA court in secret, would still be in secret, but who could argue for the privacy aspects, could argue for the Constitution, could argue for the civil liberties. And, you know, the FISA court judges don't understand technology. They don't. You know, they don't understand how it works or what the implications are. The FBI can tell them this is just a minor little thing, and when it's actually, you know, going out and sucking up everybody's information. The USA Freedom Act would have declassification of FISA court decisions at the discretion of the FISA court. It would not be mandatory. And one of the reasons behind this is that a lot of the FISA court decisions are they approve a warrant, they approve a warrant, they approve a warrant. It's most of them. The ones that are of interest and of concern are ones that reinterpret what the law says or tell the NSA that they can do things that violate the Constitution. Little things like that. And there are provisions in the USA Freedom Act that would allow the privacy advocate to petition for the information to be, for the court, the opinion to be released, even if the court wasn't that inclined. None of them expand privacy protections for non-Americans. That doesn't seem to be a real concern of our government. And then some of our colleagues who work in the tech field are worried about weakening encryption standards. The NSA doesn't want to not be able to get in through back doors into email providers, into university systems, into Google and Yahoo and wherever else they want to go. There's actually some assertion, which they've denied, that they knew for a couple years about the Heartbleed bug and exploited it for a couple years. They've also been working with the National Institute of Science and Technology to try to weaken their standards for encryption. And would it block NSA from searching Americans' data without a warrant? Only the USA Freedom Act of the current bills out there would block that. Both of these, both the House and Senate versions, stalled in committee. The reality is that politically, Senator Leahy is writing a very good bill, and Representative John Sensenbrenner is working it in the House, but they don't have the full support of their committees in either body. So somebody asked if there was maybe that was at dinner, if there was much opportunity that anything was going to happen. I would say if it doesn't happen in the next months, that it's not going to happen because we're going into an election cycle. And whatever cowardice you have, this is me speaking, whatever cowardice you think you've seen from Congress up until now, when the election season gets into full bloom, they won't do anything about anything. They don't want their opponents to be able to run ads about them weakening the protection of American civil liberties. The American public is generally concerned about this, but it depends on how it's framed. As George said, if it's framed as they're getting my phone records, or they're getting into my email, or even if they're just seeing the metadata of my email, they can tell, or just the phone, they can see that a woman called her divorce lawyer, or they can see that somebody called his cancer doctor, or any number of things. There's a whole lot of information in just metadata that the government has. The other concern, and this goes beyond libraries, is that once the government gets this information, even though they are required to minimize how long they keep it, they move it, we understand, from one database to another. So they will minimize it out of the database that they originally put it in, but they'll put it into another database that's accessible to other agencies. And so you don't know that the information that they get to protect against terrorism is going to not migrate into copyright prosecutions or any number of things. All sorts of things having to do with information people may receive or search on the internet, or emails that they may receive. They can see this item. I guess they can't see the subject line, but they can see a lot of information. And they can see the subject line if they get a permission from the FISA court to search the content. So we have actually some really good language that is out there right now, in addition to all the stuff that Edward Snowden disclosed, and that is now being, I would say, mostly very responsibly reported by the Washington Post and the New York Times and the Guardian. There was a President's Review Group set up, and they received this year's Madison Award. This was former government officials, several of whom were from the intelligence community, who said, this is not acceptable. What is happening is really not acceptable. Let me see if I can find. So, the group was established by the president to make a report and recommendations. The final report was stronger than many of us in the openness and privacy and civil liberties community expected. We had written them off. Actually, one of my neighbors was the attorney for them, and I had told him, yeah, we don't expect anything. It was good. It's actually a good report, really not even considering, it was a good report. And it has good language about the need to reduce secrecy in the arena of national security. They said a central goal of our recommendations is to increase transparency and to decrease unnecessary secrecy in order to enhance both accountability and public trust. They talked a lot about the church committee, and they said that key among the learnings from the church committee was that the American people should know enough about intelligence activities to be able to apply its common sense to the underlying issues of policy and morality. Knowledge is the key to control. Secrecy should no longer be allowed to shield the existence of constitutional, legal, and moral problems from the scrutiny of all three branches of the government or from the American people themselves. That's actually language from the church committee. So there's also, I commend the report to you. It's not short, but it's a very good read. Your library should have it, and if they don't, they should get it. The next report is from the Privacy and Civil Liberties Oversight Board, who came out with much stronger recommendations. And they said, we do not believe that the process surrounding the application of Section 215 to bulk collection comported with the kinds of public debate. They also said that they thought it was unconstitutional. They recognized, again, the need for transparency and less secrecy, which for my community is one of the key functions. And then the president on January 17th gave a very good speech, a very thoughtful speech, and talked about that he was directing the government to look at how not to do, for the government not to do bulk collection. And he said that he knows it's not enough for leaders to say, trust us, we won't abuse the data we collect. It should be obvious, though, that public debate is only useful if the public has an informed understanding about the scope and legality of the programs. And information is the key to that. So most of these current bills are not perfect. A number of us are going to be working on the USA Freedom and trying to strengthen it and trying to build support for it. How do I go to the next one? Down?
Arrow down. Yeah. There's an
Page
arrow.
down? There we go. So I think I will just leave this with you. We've probably covered most of this, provide estimates. So it doesn't change as much as we would hope it to change, but there is a decent bill out there, and we hope to make it stronger, and we hope to get it out of committee before the summer starts. And so if you're, I don't know if your senators are on the Judiciary Committee. If so,
Cory Booker might be on it. I think
You
Cory
should-
Booker is.
writing it, you should ask him to support it. And if your senators are on the Intelligence Committee, you should write and tell them not to support the Senate Intelligence Committee bill, because it's awful. It basically authorizes everything the government, codifies everything the government has been doing, and would give the NSA the cover that it wants to invade the privacy of the American public. So with that, I'm going to stop, and I think we're going to open it up to questions.
Miss a little week.
I'm going to discuss it at the table. Yeah, just going to close this.
So we have a few minutes left for questions. But Betsy, do we see any questions coming in electronically? Nothing. So how about any of the rest of you? Do you have questions you want to raise? Yes.
You had mentioned at the end of your talk about other things you could do, like not keeping records you don't need. And I was wondering if using encrypted browsing and, like you were saying, the anonymous IP addresses to different computers and encrypted email, if you could elaborate more on like what you recommend to libraries to protect themselves, software-wise?
I can't,
I think that's all.
is this on? Well, anyway, can you hear me?
Mhm.
Okay, I can't recommend that only because I'm not technically competent to recommend. What I meant by not keeping records that you don't need, are not keeping records you don't need to keep. For instance, many of our libraries have a piece of software that essentially sets up a reservation system for public access computers. So people want to come into a public library, use the internet, they can just register for a time slot on that. They don't get into an argument with the librarian about, that person's been on for 3 hours, I need to use it, whatever. And normally you need a library card in order to use this program. So the program knows who it assigned a slot to use an internet machine, and it knows which computer that person was using for browsing the internet. That information is not useful to the library the next day. It doesn't make any difference. So why retain it? Get rid of it. Many ILS programs that control the circulation of the library can have a setting so that when a book is returned or other material that has been borrowed from the library is returned, the association between the patron record and that material disappears. Some libraries set it to only happen the second time, so that if the next patron says this material is damaged, they know who the previous user was. But after that, it's only one user. There's no need to keep a history. Many patrons, on the other hand, like to keep, especially in public libraries, like to keep a history of what they've read. Ask anybody at the circ desk, at least 5 patrons a day come in and said, can you tell me whether I've read this book or not? In the past. And I can understand that. And what patrons like to do is keep a list of what they've read. But you can make that with many ILS programs and opt in. It has to be a conscious decision of the patron that they want to track that. And in the system that our consortium is migrating to, not only is it a conscious patron decision, but the staff has no access. The staff still can't answer that question. Only the patron can see his own account. Nonetheless, the information is there, and if we were compelled to fork it over, there must be some way for that information to be retrieved by a computer expert. So you have to balance things. But in many instances, it's natural to keep track of information. You've got to really think through. Is there a point to the library that makes keeping this information worthwhile, and does it outweigh our obligation to protect the privacy of our individual patrons? In terms of encryption, the other national security letter recipient, the owner of that,
Lava Net?
no, the ILS provider in New York, who received the national security letter, he's out from under the gag order, but he still can't reveal what the FBI was looking for when they came to him. But he's organizing a program that would enable libraries to route all of their public access computers out to and again, I'm beyond my technical competence here, but there is a setup so that the path that the computer took would go over to Europe, would be bounced around from a computer, it would be untraceable, so that you could still look at a particular website, but anybody who was reviewing the records would not understand what website you were looking at because the path was just too complicated. He's asking our libraries at Library Connection if they want to test this. We're debating whether or not we want to do. One of the problems is response time. If it's going around the world 3 times, what's the lag? But nevertheless, it's interesting, and so there are options like that becoming available, but when you get down to the nitty-gritty, the technical things of encryption and otherwise disguising what patrons are up to, I'm the wrong person to ask simply because of my technical ignorance.
I would actually, and I'm sure he knows better, but a wholly domestic communication, once it leaves the U.S., has no protection at all. And there are, the governments in other countries are doing the exact same thing that we are and are cooperating with one another. So, maybe.
It's good to keep in mind.
Yeah, I mean, and you really do lose your protection once it leaves the country. Any protection of a constitutional civil liberties, First Amendment sort of thing. The other thing about encryption, I'm afraid it's become pretty clear that the NSA is working hard on breaking any encryption that people can develop, and they're very good at it.
From what I read about
Yeah.
the material revealed in all of Snowden's documents, is that the encryption systems, they can get through them,
Right,
but they're so complicated and so labor intensive that it prevents the sweeping.
right, that's
So
possible.
that is
right.
like I think that's a significant difference, right?
Yeah.
I mean,
Yeah, although they say they're not going to sweep it.
So I did 2 lectures for you, one on privacy and one on national security that are posted that go into some of these issues. Next week during Choose Privacy Week, ALA has a great privacy toolkit. We are putting out a new edition next week. It will debut next week. It's got lots and lots of guidance for you about how you can avoid collecting a lot of records. The other thing is, and you know, Rutgers University Libraries is a great example of this. A lot of libraries do not even have privacy policies. Most of them have confidentiality policies. We have a model for that. Rutgers University Libraries went through a long process to create a really, really good one. One of the key issues for us that we discovered as we worked on this policy is the third-party issues. So we can protect you so much, but most of the work we do, we're going out to third parties. And you know, even if you use our database when you go through the proxy servers here at Rutgers, fine. The proxy server does not release your information when you go out there. But if you're searching ProQuest and you say, oh, you know, I want to send this to myself, I want an email with this, you are giving them your information. And when you give them your information, you are now under their privacy policy and terms, which means, you know, we're not just talking here about surveillance. We're talking about commercial monitoring of everything you do. So when I went and looked up on LLB's site the other day, some luggage, and then immediately I get an ad from LLB in my email for their luggage. I mean, you know, and we know this with Google and everybody else. I mean, we are in a surveillance society. So we want to protect ourselves from the government, but quite frankly, I'm happier having the government hold on to this information than I am most of these companies. Both Facebook and Google are under government orders right now because they so poorly manage our information. And one of the options here with these changes in the law is to let these companies hold on to it. The phone company, Google, etc., for 18 months. It's like, I don't think, you know, what protections? We don't have any protections with them. You know, at least with the government, we have some protections. So there's a lot of issues here. It's a really complex issue, as you've discovered. But we all need to be much more vigilant and realize that we give away our privacy every day in many ways. And as librarians, we have responsibilities to our users. So, you were going to speak.
I was going to say, I'll be quiet after this, you guys.
No, that's okay.
But
That's great.
Next week's Privacy Week, and
Yes.
just
Choose privacy.
choose privacy.
That
week.
means you get to choose. This is all about what you decide. You have a role in this.
But unfortunately, as a student here, I'm using Rutgers Google email, which everyone knows is now harvesting the contents of our emails for their own purposes, like you just said. And they've shut down the Rutgers email server, so we don't have an option to use that anymore. And we're using Pearson's eCollege for all the intellectual property we generate. So, and I feel like that's particularly embarrassing for a school of communication and a library to be doing. Is part of the Choose Privacy Week to, I mean, why isn't everyone using Sakai? Like, that already exists. Is there a push to use Sakai instead of
Just to make you
eCollege?
feel a little bit more creepy. In the 90s, we had a big fight with the FBI because the FBI, and they won the fight. We did. We, higher education, they have a box on our internet. They track everything in and out of universities. I forget what it's called. Yeah, we fought it long and hard, but we lost. So they're tracking everything, so, you know, sorry.
Doesn't matter if it's Google or not.
Yeah, it's really hard to hide. But good privacy policies and practices should at least minimize who has access to this stuff. And like George said, if you don't collect it, they're never gonna get it. But we also have to personally be more responsible. I'm sure all of you like me, you know, we buy stuff online, we love it, we don't have to put all of that information in again, let's just hold on to it. Well, every time you do that, you know, it's convenient, but you're giving away information.
And I think this points out another group that needs education and that too often gets overlooked in any setting is IT people. Your sysadmins and management of universities, of all institutions who are making these decisions. But if your IT folks don't get it, that because it's easier for them to do it this way and that it has privacy implications that they're just not thinking of, I think that when I was at ALA, that was one of the things that we did recommend, that people educate IT departments, because that's just not a frame of reference for a lot of people in that world.
And we can educate the basics to the public. You know, in our toolkit, we have just, you know, some real basic things you can tell the public is how to protect themselves better. Because we think young people don't know how to protect themselves, but they're much better than some of us older folks. You know, we go on something like Facebook or whatever, and there are protections there if you know how to use them. And most of us don't even realize that we need to know how to use them. So, and young people at least have figured that much out. So,
Are there questions?
probably
from
quite a
the-
few.
We have a question from online.
So how, if there is any way, to protect the privacy of, you know, the users logging into licensed content? Because, you know, once the licensed content provider will collect the metadata of whatever's being used or downloaded. So is there a way, what's the way?
Yeah, so it gets tricky with databases because we go through a proxy server. We do not reveal the information about you when you go through the server, okay? So what we're concerned about with privacy protection is not what you're looking at, that what the stuff you're looking at is public, is connecting you to the stuff you're looking at. So it's your personally identifiable information linked to that information. So that's what's of concern. So who was sending the email? It's you personally connected to something, or you personally connected to what you're circulating, or whatever. So that's what we're concerned about here. So when you're using a third-party database, we are blocking your name from that. But if you voluntarily give it to them when they ask you, like, do you want to create a list? You on all these databases now you can create your own personal files. You can do all this, but you can only do that with your personal information. So you choose that. So this is when we say choose privacy week, you can choose privacy, but you have to be aware that you're giving up your privacy very often for convenience and for other reasons. So you have a role to play in this.
No, I was just going to say that through databases, you're only going through the proxy if you're off campus. If you're not off campus, you're going through your regular IP. You can be identified, actually, as the user.
Yeah.
And the third-party service, if you use Elsevier and read their terms and conditions, see, once you're on an Elsevier site, it's their terms and conditions that apply. It's not the university's terms and conditions that apply. And so if you look at those, they will say, and Elsevier in particular, will say, we will be collecting this data and we will be following the patterns, etc. And they're very upfront about it, but they are collecting the data. So the privacy is difficult to. I just was on the Heathrow Express in London, and they said they had Wi-Fi service, and I used the Wi-Fi service. And I just got an email from Heathrow, the train service, to ask how I liked their service. I didn't fill out anything to get that information. Right? But they knew I was there. I was overseas, and they told me how long I used the service while I was on the train, which was amazing to me. I mean, how fast they were able to give us that.
So let me just make clear though, this issue about the IP address, I did not only the policy, but I did a complete audit of
No,
our
I know. I
records.
understand.
And so the IP address, we keep that information.
Yeah.
If Elsevier or ProQuest, or if they suspect there's a problem, they can come and ask us to identify at what time and what information. So we're the ones who maintain that information. Under certain conditions, we are willing to explore the problem, but we're the ones who secure that information. So, and we don't keep it in perpetuity,
No, we don't.
and we secure it fairly well. So in the lecture, I talk about how part of our policy is how do we secure the information. So, but they can't get directly to it
It
and
depends.
connect it to a particular person. That information, they have to go through us to get that, and we have to determine whether or not, A, we have the information, and B, whether or not it's information we reveal to them or we deal with the person. Is that fair to say?
Well, I mean, when there's been abuse, they've been able to tell me where the abuse came from.
Right, that it's only us that can identify.
The individual, sometimes.
Right, right.
Yeah.
I have a question. What about something like the New Jersey Open Public Records Act? I was reading about Lincoln Public Library a few months ago. They were compelled by the New Jersey Superior Court to reveal the name of one of their library trustees who owed a large amount of fines. And the library had originally argued that that would violate patron privacy. So I was hoping you'd be able to comment on that a bit.
Well,
I know in Connecticut, I don't think that would fly, because there's an absolute prohibition against libraries revealing anything about patrons without court order.
We have in New Jersey, like Connecticut, we all have these state statutes, almost every state, and the state library statute, privacy statute would protect that information. But if there's something about that information that they might get an angle on through the Oprah law, it's possible, but I don't think so. Libraries, I mean, if they had a court order, they could give it up, but not for public use, but for a legal purpose, if the court ordered it. But that's probably not.
But what you really need is something explicit in the Open Public Records Law that recognizes the protection of that recognizes the other statute. So, information that was withheld under whatever that statute is exempt from.
And it's probably there because, health records, financial records,
Right.
there's laws that cover a
Personal
lot of
privacy,
specific
right.
kinds of records. So it probably is a more general statement. I haven't
Right.
looked at it for that
No,
purpose,
right.
but, one of the tricky things about the Federal Patriot Act and these other laws is they override these state laws. So we have these state provisions, but, when the feds come with the order, they can override everything. And that's one of the reasons we freak out so much, because the protections we put in place aren't valid under those circumstances unless you're George Christian or John
I was going to
Lewis.
say, except that theoretically the Constitution overrides the
Right.
executive branch of government.
But as we've been hearing from Patrice, well, maybe not. Not
Well,
often
you have to
enough.
know what they're doing. Yeah.
So this whole cloak of secrecy has really been a big problem, and it's a very core value of ours, the privacy issues, the intellectual freedom issues, the be able to speak issues. But secrecy is also of great concern to us as librarians because we can't do the job we're supposed to do if the key information the public needs is not available.
Right, and if you don't know that what the government is doing is the opposite or contrary to what the law says, then you're in a untenable position in asserting your rights in all innocence, because the court may have said that what the NSA or the FBI is doing is authorized under. So you can go to court, but you might have to go to the FISA court where you can't go to the FISA court. And it becomes very, very convoluted. And as Nancy said, in order to hold government accountable and to keep our openness, our open society, we need to rein in the secrecy. And it's an ongoing struggle. Yeah.
Question. Has there been a tremendous public outcry to your organization regarding these issues? Have you seen a huge increase in interest?
Oh, increase in interest in membership? No.
That's right.
The people who usually benefit from this, as they did with the Patriot Act, are folks like the ACLU. They get the members and the money. They bought a building on Section 215. No, we haven't had enormous pushback. And it's partly because there are so many groups, especially in DC, that are working on, we focus on the secrecy part of it. And other groups are focusing more on the privacy and civil liberties parts of it. And they tend to get more attention in the media. Those of us that work on the openness and the anti-secrecy aspects, it's like, oh yeah, but whatever. Because the other's more tangible. It's things that people perceive as having an impact on me. Whereas, the government keeping things from me or misleading Congress, it's like, yeah, well, so what? What's new? And the connection is hard to make in people's minds that there really is a nexus there that subverts the privacy and civil liberties. Because if you don't know what's going on, then you can't really protect those.
But I think, it's one of the things that I'm really proud of as a librarian is, even though we haven't won the fight on the public policy side, I think we really have made great inroads on the fight for public opinion. That librarians like George stood strong, and people call that section of the Patriot Act the library provision. Word library is nowhere in that whole 342 pages. But when Rachel Maddow introduced the Ed Snowden revelations last summer, she introduced the whole section with George Christian and what the librarians did. I mean, people in this country resonate with this issue as much as they do with anything about this whole surveillance issue. Is they really feel that using their local library is a privilege and a right that is as American as anything. And if you violate that, you are really crossing the line. They might not feel so much you crossing the line when they're patting you down at the airport. And you may feel, that's just fine. But, when it gets into your local library, that's really sacred.
What I'm reading and what I'm looking at on the internet.
It's really interesting when we were able to go public. I'm still pretty much an anonymous guy. It'd be hard to find my office in Windsor, Connecticut. But my three colleagues on the board of directors, they're all library directors. They're out there facing the public every day. The two women got many bouquets of flowers from their patrons and hugs and congratulations. And Peter Chase didn't get any hugs or flowers, but people came up and thanked him for what he was doing. So, public really, it's resonated with the public a lot.
But I think you've got to realize just how powerful libraries are, and we can shape the future. We may not be able to move Congress, but if we've been able to move public opinion as much as we have on this issue, I think that's just remarkable, I mean, sometimes, even if you're going to lose, you got to fight the fight, and we did win, I think, on many levels, and one is the public really cares about this issue when it comes to us, and they get this part of the issue.
And it's a long struggle. Culturally, we have a history, right from the beginning of the United States, is that whenever we perceive that we're being threatened from abroad, the Constitution goes out the windows. The second President of the United States, John Adams, a founding father, under his administration, the Alien and Sedition Acts were passed, in which members of Congress were imprisoned, newspaper editors were imprisoned, or tarred and feathered. And that was just over an imagined issue. We thought we were either going to go to war with France or Britain in the Napoleonic Wars, and it didn't happen. It didn't happen until 1812, long after Adams was out of the presidency. Lincoln, he
Suspended
suspended
habeas
habeas
corpus.
corpus. In World War I, there was the Red Scare. J. Edgar Hoover really got his start with the Red Scare after that. After World War II, it was McCarthyism.
Well, there was the internment of Japanese during.
Internment of Japanese. In my generation, with Vietnam, there was really a lot of government involvement in focusing on dissenters. And it takes a while to unwind all of this stuff. But I think, we're educating the public. And I think eventually the public has to, what I really learned from this is that our liberties are not guaranteed by the Constitution. Our liberties are guaranteed to the extent we are willing to insist that the provisions of the Constitution be honored. And until the public really grasps that as a whole, we're not going to see the sea change that we need to get all this repealed.
So George Christian was one of the only people that stood up. There was 500,000 of these national security letters have gone out. And you are looking at the one person who said no. 500,000 people didn't
Yeah, as I said,
oppose these acts.
they're going to live with that secret. They're going to carry the secret to the graves that they were served with the national security letter, that they helped the FBI look at their fellow citizens. But it's also how we frame things. When you get into a debate, or when you talk to people, or ask your congressman when they're thinking legislation, what in their mind is the difference between a police force authorized to act in secrecy and secret police? It's how you frame this.
Yeah. I like that. Anything else from the,
This is me.
oh, for you,
Sure.
okay.
Okay.
It's not really a question so much as a comment. Like, you both mentioned that you've been pretty lucky, and the whole framing of the question. Also, it is important to notice who is the person bringing these challenges, because some, first of all, the people who tend to get screened and focused on are a certain subset of people. It's not everyone.
No, right.
They don't really care about what's happening in some random town in New Hampshire. They're focusing on, well, depending on the town, I guess.
Yeah.
But they're focusing more on, Detroit and Chicago,
Right,
and
where there's large.
certain parts
right.
of Chicago too, not all of
Right.
Chicago. So I think it's just important to remember, in the fight against privacy, the fight for privacy and for intellectual freedom, who has more power to do so, and to try and make sure that you're fighting for the other people who can't really afford to fight for it.
Yes. Thank you. That's really important. And I think particularly when it comes to physical surveillance and the screening and that sort of thing, I think that's absolutely true. And we've seen, in New York City, they had the profiling
And in
and
New
other
Jersey,
places, yeah.
don't forget in New Jersey too.
Well, I don't, yeah,
They came to New Jersey, they came to Rutgers.
right.
They profiled.
And they're not profiling everybody. Yeah, exactly. It's particular communities and particular faiths. that they're providing. That's exactly a critical point.
So I want to thank our speakers, give them a big hand.